Let's talk about the 2019 Australian family law case of Bircher and Bircher. This was a case heard in Brisbane, and each of the parents were self-represented. This is an interesting case for two primary reasons. Firstly, it's a case where the court determined that it was in the children's best interest to spend equal time with each parent, even though there was an extremely high level of parental conflict. Secondly, this is a case where the court made orders to split parental responsibility between the parents. There was an order that the father have sole parental responsibility, so decision-making in relation to health, and there was an order that the mother have sole parental responsibility, so decision-making in relation to schooling, so where two of the children were to go to school. They were to share equally all other aspects of parental responsibility. Just a reminder, parental responsibility does not relate to day-to-day decision-making or time with either parent. It relates to major long-term decisions. For example, major decisions about schooling, education, religion, health. All right, let's take a look at this case from the beginning. There were already final parenting orders that were made in 2014. The 2014 parenting orders provided for the parents to have equal shared parental responsibility in relation to all aspects, and for the children to live with the mother and spend 5 nights a fortnight and half of school holidays with the father. There were 3 subject children in this case: subject child B, born 2007, child C, born 2008, and child D, born 2009. Fast forward to 2018, where the mother initiated court proceedings seeking a reduction of the father's time to 3 nights a fortnight and no time during school holidays. The father responded to this application seeking an increase in his time to include equal time, 7 days with him and then 7 days with the mother to rotate. Each parent sought an order for sole parental responsibility in relation to all aspects of parenting. Notably, by the end of the trial, the mother changed her position and said that the current order should continue. At paragraph 81, the judge commented that the children had been involved in the parents' disputes since birth and that they had suffered because of it. Due to the extremely high level of parental conflict, the judge noted that they considered making orders for the children to live with one parent and spend no time at all with the other parent. This was to avoid the children being exposed to ongoing parental conflict. Ultimately, the court didn't make a no-time order because the children expressed love for both parents and there appeared to be some benefit in the children maintaining a relationship with each parent. An independent children's lawyer is a lawyer who acts for the children and not for either of the parents. Interestingly, in this case, the ICL's position was that the current orders, so the 2014 orders, should continue, save for a few changes to some ancillary orders. One of the children described living with their parents and the high level of parental conflict as like living in a war. The court noted that this was a reference to the parents' long history of putting their own self-righteous point scoring ahead of the children's welfare. The court made scathing comments about the mother and the father throughout the judgment in response to their parental conflict and lack of insight in relation to the harm it could cause and may have already caused the children. The mother was unemployed and she received income of $64,000 per annum from Centrelink payments and child support, and that included a disability pension in relation to the children and their diagnosis of Autism Spectrum Disorder. The court noted that the parents had been involved in litigation against each other every year since 2011. The court noted that the children are acutely aware that their parents do not like each other and that much of their dispute relates to the parents' inability to agree on parenting issues like schooling, extracurricular activities, school camps, uniforms, diet, and health issues. There were many examples of parental conflict in the case. I'm not going to go over all of them. I'm going to go over 2 brief examples. I'm going to pop the citation to this case down below. So if you're interested, go and take a look at the entire judgment. You can use Ostley to search this case for free. There was an incident on 4 February 2016. Child C had recently undergone surgery and was not attending school on the day of changeover. The father had attended the medical consultation between the doctor and the children, as he was entitled to do pursuant to the 2014 orders. Usually changeover occurred at school. But following the medical appointment, the father expected to take child C from there. At the end of the consultation, the mother put the children in her car. She says that the father did not say anything other than follow the orders. The mother said she didn't know what he meant by that, and they began to argue outside of the car but in clear sight of the children. The father stood behind the mother's car. The mother reversed back 3 times, and each time the father moved backwards but not out of the way. On the 4th reverse, the mother was able to leave the car park. The children witnessed this incident and they were very distressed by it. The mother drove a short distance to the school where the boys were dropped off and C went into the father's care. Once the mother left, the father signed the boys out of school and took all 3 children home with him. The mother was asked during her oral evidence why changeover did not simply happen at the doctor's surgery. The mother conceded that this could have happened, but she added disingenuously, in the court's view, that she was ignorant of the father's purpose in being there. She said it was not a normal situation and she felt intimidated by the father, whom she described as aggressive. The incident so could have easily been avoided by the mother suggesting the children go with the father. When the father was asked whether in hindsight it would have been better for him to simply meet the mother at school in accordance with the arrangements made the night before, he responded, "It would have been better in hindsight if C had just been handed over." The court noted that his reply was a stunning example of his lack of insight into the impact of his actions on the children. The court noted that when it was clear the mother was not going to effect changeover in the car park, the father so easily could have left and met her at school. Each parent was focused on winning the argument rather than the impact that their parental conflict may have had on the children, who were highly distressed. During the cross-examination of the father by the mother, again, they were self-represented, they started to bicker and argue between themselves, and the court had to call their conduct to a halt. The court noted their respective self-righteousness was breathtaking. Another brief example is the father took one of the children to get her ear pierced when he knew the mother did not want her to get her ears pierced. That was a breach of the 2014 orders, and issues like this kept popping up. Now let's take a look at the health issues. The children had attended upon 47 different health professionals since birth, which the court referred to as an extraordinary number. The children's diagnoses of autism spectrum disorder had been an ongoing source of significant dispute between the parents. The mother maintains that the children have the disorder while the father disputes it. The children receive educational and other support as a result of the diagnoses, and the mother receives a carer's pension of approximately $900 a fortnight. Dr. G was involved in the proceedings and reviewed medical and psychological reports for the children. She stated that she definitely wouldn't be able to say that they would still meet the criteria for autism spectrum disorder anymore. Dr. L, a psychiatrist, opined in a report dated 8 June 2018 that child C did not present with features of a young girl with ASD. In Dr. G's view, it's necessary to review diagnoses of ASD every 3 years because it's a developmental disorder, which means that symptoms can change. Dr. G stated that exposure to ongoing conflict was definitely affecting the children emotionally. Dr. G made it clear that child B's presentation may have more to do with the impact of years of exposure to parental conflict rather than ASD. The court noted that the mother demonstrated significant resistance to any suggestion that child C and D do not have ASD and indicated her intention to continue to rely on the old diagnoses for the purpose of continuing to receive a carer's pension and educational support, which the mother believes C and D require. The father raised the excessive attendance at health professionals as a significant risk issue, suggesting that the mother's determination to gain access to Centrelink carer's pension, she has engaged in doctor shopping and has in effect created a false reality for the children that they suffer a disability when they do not. The court noted that the mother's rejection of Dr. G's diagnosis that at least child C and D do not meet the criteria for ASD to be curious, to say the least. The court noted that one would have thought she would be delighted to hear that the children are doing so well at school across all areas. And that's why the court made orders for the father to have sole parental responsibility in relation to health issues. What do you think about the outcome of this case? Let me know in the comment section down below. Do you think it was a fair outcome? This video contains legal information, not legal advice. I'm a family and divorce lawyer practicing in New South Wales, Australia.